Africa's heads of state and government converged in Addis Ababa, Ethiopia for an extraordinary summit to review Africa's relations with the International Criminal Court. Like in all negotiations, the summit was characterized with behind-the-scenes lobbying and intrigues that saw the leaders emerge with a common stand in the end. Let's take a look.
His impending November date with the ICC is the reason for this emergency African Union summit. But as the heads of state got down to business, it was clear from the beginning that the tone had somewhat changed.
It should be underscored that our goal is not and should not be a crusade against ICC, but a solemn call for the organization to take Africa's concerns seriously.
Among those concerns is that the Hague-based court is only targeting Africans, perhaps best explained by the fact that all the 8 cases before the ICC are on Africa. And Kenya, which had requested the meeting, was hoping to garner support for a process it has already begun at home, that of severing ties with the ICC. But as the AU Executive Council burnt the midnight oil, it was clear that this was not to be, with strong divisions between Anglophone and Francophone countries over the issue, Kenya seemingly taking it in stride.
There is no time at all that we have said that we want to move out of the ICC.
Sources tell CCTV among the major concerns for the dissenting voices were their strong relations with the West, to date Africa's biggest development partner. Many view their membership of the ICC as proof enough of their pledge to fight impunity. They also expressed concern at the slow pace by the AU in resolving conflicts on the continent. These countries included Burkina Faso, Senegal, Gambia, Mali and the Ivory Coast, whose former leader is already at the ICC. They argued that the AU should pursue their concerns with the UN Security Council and the state parties to the Rome Statute Forum next month. Strong supporters for an immediate declaration of a withdrawal were Kenya, Uganda, Rwanda, Ethiopia, Nigeria, Sudan, South Africa, Zimbabwe, Ghana, Malawi, Tanzania and Algeria.
Most of us here are looking for respect for Africa.
UN Secretary General Ban Ki-moon is said to have called each of the presidents at the meeting to persuade them against a withdrawal, promising to use his position at the State Parties Forum to address the concerns raised. Members were, however, unanimous in agreeing that the ICC should not prosecute sitting presidents. Now, the summit comes a month to the start of President Kenyatta's trial. And while the outcome of the summit serves as a temporary reprieve for the ICC, the court still finds itself in the grip of credibility concerns. And some experts say the summit has laid the ground for what may turn out to be Africa's frosty relations with the ICC. Jane Keo, CCTV, Addis Ababa, Ethiopia.
Joining me now is Dr. David Hoyle, the Director of the African Research Center. Joining me on the program. Welcome on the program today. And Dr. David Matsanga, an African political analyst, joining us also on the program. Welcome. David, I'm going to start off with you now. This is an unprecedented summit called by the African Union. Was it necessary?
It is necessary, and we have got to leave this place with a definite answer. What do we want to do with ICC? Because we have talked and talked. Resolutions have been passed. Resolutions have been recommended to the Security Council. The continent of Africa needs a decision. The Kenyan scenario especially is a scenario that I have been so much hurt about, because witnesses were bought, procured, every type of methods of investigations were flawed.
Let's stay for the moment with the Africa's concerns here with the ICC. What is at the heart of the concern from the African states?
I mean, the ICC does not respect the recommendations of African Union. And then we have on the Security Council member states that are not signatory to the ICC statute. And they give instructions to the ICC. For example, the United States, Russia, name them. All of them are not signatories. But you find the United States taking a hand to direct what ICC should do. Therefore, Africans are not happy at the moment. The heads of states are saying enough is enough. If there are no changes, in the court, OTP office has got a problem. If they don't change that, then we call it a day, and then we look for some other alternative.
All right. Professor Holdo, what is at stake for the ICC and what is at stake for Africa?
Well, it comes down to sovereignty. At the end of the day, African states are sovereign, and I think many of them actually initially welcomed the concept of the ICC, and of course many of them were amongst the founding members of the court after they signed the statute. The last 10 years has actually shown how shallow the court has been. The court is not independent. Dr. David has just mentioned the court's relationship with the UN Security Council. It's not independent because at the end of the day, it gives the UN Security Council rights of deferral and referral, which no independent court would actually give. The key thing really is that it's every one of the claims made by the court have been shown to be false. It's not independent. It says it's an international court, but in fact it's a European-funded, European-driven entity. The ICC is in effect little more than an instrument of European foreign policy. It's been so totally prostituted to Western interests, and on top of that, it's just not a functional court.
All right. The African Union, though, just coming back to that point, the African Union has issued decisions and statements before on the ICC. This is not the first time. But at the moment, though, what is the immediate concern for African Union states?
I think it comes down to just being ignored. And as you mentioned earlier, there's a very arrogant condescension on the part of the ICC. And this also, has its root, I think, in the fact that it's essentially a European entity. The big 5 European colonial powers within Africa are the big 5 directing powers within the ICC. And almost by osmosis, almost by inheritance, they seem to have the same attitude actually towards Africa, which is that you don't count. We know what's in your best interests. We'll impose, in some senses, white man's justice on Africa. Although again, it's a travesty of even that term. It's a sham process which they use actually to keep Africa, unfortunately, destabilized.
Right.
That's the result of it.
Well, the ICC has not listened before. I mean, Africa has made requests before the UN Security Council before. They have been ignored, according to what the African Union has been saying. Will the ICC, though, listen this time around?
Well, I think, the concept of a mass withdrawal from the ICC is a very, very personal one. But even if 2 or 3 African countries that are signatories leave the ICC, that's enough. That's enough actually for the death knell of the ICC. The ICC then will actually become, in many ways, irrelevant. So even if all the member states actually don't leave, just a few would make that case actually very, very effectively. And that's actually what has to happen. One of the instruments, of course, used by the European Union, and this is how it ties back into the court, of course, is that they have wedded European Union trade and aid protocols to membership and cooperation with the ICC. So if an African state says, we are not going to cooperate with the ICC and we are a member, they will have vast monies withheld from them. Sudan, for example, has had 600 million euros withheld from it because it's not playing the ICC game. In fact, it's not even a member of the ICC. So there's a large amount of economic blackmail linked into the ICC membership by the European Union states that actually direct it.
All right, we'll come to that point in a moment. But David, there were 3 proposals being put here before the table by the African Union member states. Now, one of them was consideration of withdrawal from the Rome Statute, deferral of the Kenyan cases at the ICC, and a push for reform of the ICC. Is there a consensus among African states that this needs to be done?
Reforms will not help at this hour. We need a determination. We have no time on our hands. We know very well that the ICC chief prosecutor is moving to remove the suspensive ruling which was put on the president of Kenya, the deputy president of Kenya, and that suspensive ruling could fall any time. So reform can come later. That can be discussed by diplomats in Washington and Amsterdam and The Hague. We need a determination. Do we do a referral? Let's do a referral. Kenya has a lot of problems, security problems now, which are regional. There is no way Kenya leadership should be involved in looking at ICC issue other than looking at the regional peace, of which the Americans themselves caused the regional problem. They went into Somalia in 1991, they withdrew, and they left Somalia for us to look after. Uganda, Kenya, are paying with their blood in Somalia. Why should we have an ICC if we are looking for Nazi criminals 70 years after the end of the Second World War, and we are putting them before court? Why are we rushing with African suspects? Why? It's because the people want to make it a point to tame Africa under that lock and the key of ICC. There is nothing else. So if we are going to bring back sanity in ICC on African continent, first we need a deferral. It must 12 months, 24 months, you review after 12 months. Allow Kenya to strengthen its borders, its security operations, allow Uhuru Kenyatta. If you want Uhuru Kenyatta and Ruto, you can get them after their term has ended. Why are we rushing today? They have a program. And let me be frank here. One of the countries that has got a program with ICC is the French. You realize that the French pay from the porter who cleans the toilet in the ICC up to the judge. So they are calling it a shot. That's why you see countries in Africa now like Mauritius that are French-based. They are saying, oh, we have to wait and do this. Most of these countries are now trying to have second thoughts.
All right, let's just come to that reforming the ICC, though. Does the ICC itself feel that there's need for reforms? And what would that entail in terms of reforming the ICC?
Well, I think the best working description for the ICC is that it's autistic. It has its own very narrow, very inward-looking existence. And I really don't think you have a huge amount of room for reform. This is a €1 billion industry. It's like actually trying to stop an oil tanker. It's carrying on regardless of the mistakes it's made, regardless of the peace processes it has destroyed within Africa. It's just going to actually continue for as long as it can as $1 billion industry, €1 billion industry. Of course, it also serves a number of Western interests, and that also gives it a certain amount of momentum. So reform, I don't think you're going to get reform. The ICC itself is actually unaccountable. In theory, it's accountable to the Assembly of State Parties, which are representatives of the member states. But that actually meets once or twice a year, and it's actually represented by diplomats, not lawyers. So it comes back to actually political control over court. So you can't expect any significant change anytime soon. The only real options that will make them think are countries that actually withdraw. So even, as I said, even if you have 1 or 2 countries that leave, that is an earthquake within the ICC establishment.
All right, Professor Hoyle, we'll stop there for a moment and take a short break and return to this discussion in a moment. Stay with us. All right, welcome back to the program. Africa's relationship with the International Criminal Court in focus at the African Union Extraordinary Summit here in Addis Ababa, Ethiopia. My guest on the program, still with me, Professor David Hoyle, Director of the African Research Center, and Dr. David Matsanga, African Political Analyst, joining me on the program today. David, let me come here to you now. In terms of options, does Africa see that it has other options apart from withdrawal to ensure that its voice is heard?
First of all, Africa needs to put a lot of efforts in a redemption strategy. We need a redemption strategy on the ground. Most of the country, for example, redemption strategy in Kenya case would be we charge more people on local mechanism so that there is no need of an outside interference. If we have more people charged with who committed more crimes, some other crimes, that will bar the ICC coming. Mark you, the ICC was created on complementarity status, that it must complement with local mechanism. But if you don't have the local mechanism as an African country, we shall always open doors for the ICC to come in and poke nose in our affairs.
Which leaves the question, though, where is the African Court of Justice that Africa has been talking about?
This year, I think we sat in this same hall and ratified the African Treaty, Court of Justice, and we decided. But again, the problem here comes with funding. The funding, we have to look at the same European countries that have actually given, whom we are saying they are in ICC, and therefore they will frustrate the funding. African countries should come out with a position, go to friends, go to China, go to Russia, go to some other country, Brazil, ask them for funding for this court, so that this court of African Union can now be there, and then you can transfer all these cases that are harassing Africa into this court. Without that, and we talk, and another 10 years will pass without this court functioning. More of the ICC interference will come on the continent. So it is important that the leaders listen and divert. They must look for some other alternatives other than depending on the European Union, which ties aid with your human rights record. If your human rights record is very bad in Europe, according to the European setup, you will not be given any aid. If you refuse to be in ICC, that's why Botswana plays with it all the time. You have seen the GDP of Botswana is so high, people are happy because of that. So it is high time that Africa looked at other alternatives of funding for the courts, so that this court can be established in Arusha, as we had suggested, or other places. Other than that, the ICC keeps on knocking our doors. The ICC keeps on using Article 15, invocation of Article 16 of the Rome Statute, gives the freelance Lone Ranger, a prosecutor, to come and choose people, how tall, how short you are, and take you, because there is no more mechanism on the ground. And that is what is the problem with most of these cases.
Yes, where does that leave, though, cases of countries such as DRC, such as Cote d'Ivoire? I mean, given the uproar over ISIS's relationship with Africa and whatever decision Africa is going to make moving forward, where does that leave such countries?
Well, this is also one of the interesting issues about the ICC's involvement in Africa. The ICC, as Dr. David mentioned, is only meant to come into action with an African country, in fact, so internationally in theory, but now only in Africa, when local courts are unable or unwilling to prosecute the most serious of crimes. Now, within the eastern part of the DRC, you have functional courts. The European Union has spent hundreds of millions of euros over the last 10 years in making sure that there's a functional system there. So there was no reason for the ICC to take Lubanga, who was already in prison in DRC for worse crimes than the crimes he was accused of at The Hague. No reason for them to have actually done that. Similarly also in Uganda. The Ugandan legal system actually functions. It's a functional system. There was no suggestion that the Museveni government wasn't keen to capture and put on trial the LRA rebels. In the case of the Ivory Coast, you have an interesting situation where the former president tried to invoke the ICC's involvement in Ivory Coast to look at the activities of the rebels in 2006. The ICC ignored him then. When that president is actually overthrown, or was actually replaced by the sitting president, when he invites the ICC to come in, they agree immediately, and the former president is actually taken to The Hague. But then, when the ICC actually wants to do follow-ups, the government in Ivory Coast now says, no, we are not going to surrender anyone else. We won't be actually working with you anymore. So they've, in effect, themselves manipulated the system. Exactly who has actually done it to whom, I don't know. If the ICC is actually manipulated the Ivory Coast or vice versa, hard to work out. But those are manipulations. Those are that's not justice. That's actually game playing with the court. And that was also the case in the DRC, and the case in Uganda, and also to an extent the case in Sudan.
Isn't there a concern, though, because Africa is seeking full immunities for sitting African heads of state here from prosecution while in office? Isn't there a danger, perhaps, that, rogue leaders, so to call them as they have been called by the West, may take advantage of that clause?
Well, I think at the end of the day, in international law, sitting heads of state have immunity. I mean, the Vienna Convention is very, very clear on that. So that's not really the issue at here, and that really should not have been raised at this extraordinary summit, because the issue that should have been raised is the fact that the ICC is not what it said it was. The ICC is a selective European court for Africa, and Africa only. And it's not even a real court in that sense either. So that's the key issue. Immunity is immunity. I mean, at the end of the day, every head of state in office exercises that. That's why it's actually possible for indicted heads of state to go to the UN General Assembly. Right. The reason why President Bashir did not attend the UN Assembly last month wasn't because he was not able to do so. It was because the Americans chose not to give him a visa.
All right, David, though, if sitting heads of state have immunity according to the Geneva Convention, then why does Africa feel that it needs to seek that from the ICC?
There are two reasons. One, seeking to remove the clause that you wait until the president leaves is a very good suggestion, because there is nobody in Europe who has ever brought a president on trial or a prime minister. We haven't. Is there anyone in history? Even after the Second World War, we looked for the Nazi criminals and put them on trial when they had finished the war. It is the first time that ICC is setting a precedent where a sitting president is taken away from his people, whether they voted wrongly or rightly, and locked up in The Hague. That's why African leaders are saying enough is enough on that one. They need guarantee that while they are in office, they should be allowed to execute their duties by the mandate given to them by the nationals. Two, the other issue of removing why is a worry. There is also a worry of a witch hunt. Somebody would just go, some powers could initiate a shootout in your country, and then they come and they say, no, you go to Hague. So some of the presidents are getting worried, because there is a lot of, the democracy in Africa has not evolved to a degree where we can understand devolution, for example, very quietly in Kenya, and we say we move on. We need time. So people are worried that it could be used as a weapon to come and take them. But to come back to one point that Prof made of Libya, the Libyan scenario, which we have forgotten. Said Gaddafi was indicted by the ICC. But today, Said Gaddafi remains in a territory which is held by the rebels, and his fingers are being cut one by one on everyday basis by the same rebels as they want. But ICC came in and said it through a warrant. ICC has not tried to go and enforce, to tell America to go and pick Said and bring, because America and the French are the ones that supervise Libya. Why is it that ICC is only focused on certain countries in Africa, and then we have left Said Gaddafi to die on the law of Hammurabi, what do you call it in a Bible? We've left him to be cut a finger every day in the hands of rebels. This is why people are getting scared on the continent. Leaders are also scared, because most of them, their democratic records are not up to the level. They get worried that if I leave office today, somebody will come for me. Even if I'm in office, my political opponent says my votes were stolen. So you come and help me. A few people die in Kampala, a few people die in Zimbabwe. This is what they expect to do. The Security Council to push a resolution, catch Mugabe, and take Mugabe out because he has killed some people on the streets of Harare. This is what is making Africa very scared, and therefore they are pushing for that to be put in the Rome Statute. After all, statutes change, evolve. Why is it not evolving? Why doesn't the Rome Statute that we formed in 1998 change? The chief prosecutor has too many powers, too much powers, bigger than the judge. She can decide on what to do. So it has to be changed. A constitution is not static.
All right. Professor Hoyle, though, what does the future now portend for ICC-Africa relations?
Just one very quick observation on the Libya and Kenya issues. The ICC actually this week said that the people who they indicted in Libya, Saif al-Gaddafi and the former intelligence chief, Sanusi, can be tried in Libya. Right. Now, Libya right now does not have a functional judicial system. As you saw this week, the Prime Minister was abducted by one faction against the other. So it's evolving at this moment in time. You know, the legal system is not intact, it's very flawed, and it's in the hands of militias, basically. But the ICC said you can try these people who are ICC indictees in this very flawed legal system in Libya, but you cannot try Kenyans in their own countries within their own very well-established legal system.
What is informing that decision, though, do you think?
Well, I think at the end of the day, the European countries, France and Britain and Italy, do not want Saif al-Gaddafi to be able to actually produce evidence of their involvements with the Gaddafi governments over a number of years. There's a lot of stuff there which the European countries who control the ICC do not want to come out. So that's obvious. So you have this incredible, disconnect that it's okay to try people within a very patently flawed system, but not actually within an Anglo-Saxon standard sort of British legal system within Kenya. And that's game playing, it's many things, but it's not justice. Where do we go from here? The African Union has to actually leave en masse from the ICC. That's the only real wake-up call that the ICC will have. If that happens, the ICC becomes irrelevant. It becomes like the League of Nations prior to World War II. That's the end goal. Even if 3 or 4 countries leave, that also is enough to begin the process of the end of the ICC.
All right, David, you have the last word on this. Where does this leave the ICC and Africa?
Every country, especially Kenya, should move very fast to there is room to terminate. You can terminate, ask for termination under Article 53, because we have now evidence that all the witnesses were procured. And so you move. The Attorney General of the Republic of Kenya should move now to terminate and ask instead of putting amicus curiae for explaining to the MPs what the MPs want to do, let the Attorney General move to make an amicus curiae to terminate. Let's do a reverse psychology. If you move, let them ask, why did Kenya move out? Because evidence was corrupted. Therefore, they will reform. But if you ask for reform now, that is useless. Thank you.
All right, Dr. David Matsanga, Africa political analyst, and Professor David Hoyle, Director of the African Research Institute. Thank you very much for joining us here in Addis Ababa, Ethiopia, at the African Union headquarters. Well, this week, Talk Africa is in Addis Ababa, Ethiopia, the African Union headquarters, following the developments of Africa's relationship with the International Criminal Court, where the African Union has called an extraordinary summit to debate that issue. I'm Beatrice Marshall in Addis Ababa. Thank you for joining me, and goodbye.